Good morning,
Are you
Commissioners.
well this morning?
I'm well this morning, thank you.
Good. Are you ready to start?
Yes, CJ?
Okay.
CJ, with your permission.
Sorry?
I'm saying with your permission,
Yes.
I would like to apologize to the CJ and the honorable commissioners in that last year I was invited for the interviews. I could not make it for some reasons. It was a conscious decision, I suppose, with the anxiety and level of preparedness at the time. I thought it was prudent for me to withdraw. I sincerely apologize for the inconvenience caused, and I know for a fact that there's a lot that needs to be done in preparation of these particular interviews. So hopefully you'll find it in your heart to forgive me for not appearing in the last interview last year.
You are forgiven.
I beg your pardon?
You are forgiven.
Thank you, CJ.
So you feel ready now?
I'm ready now, CJ.
Well, that's what matters.
Thank you.
Yeah. Okay. You hold 3 law degree, 2 law degrees and LLB from the University of Zululand.
Indeed, CJ.
And an LLM in international business law.
Yes.
From the, is it Freie?
It's Freie University.
Freie University, Netherlands. What is that?
Attention, please. I would like to inform you that.
Where did that come from? Yeah. And an MBA.
Indeed, CJ.
I see this name everywhere all the time, but I can't pronounce it. Is it Regenesis? What's that institution called?
It's Regenesis Business
Regenesis,
School.
all right.
Indeed.
Okay. Between 1990 and 2000, you worked for the city of Johannesburg, doing, you have the number of roles there. What exactly did you do?
CJ, that was immediately when I finished matric. I think it was 1989. I was still fairly young by then, obviously, with an expectation of myself having to go to tertiary or institution, but then it so happened, obviously, in respect of limited resources from my parents, then I ended up seeking employment so that I could service myself in respect of my education. How it came about that I got to be employed at the Johannesburg City Council, I was studying, doing my initial diploma in municipal administration. And I was doing it with the Technicon SA by then. So seeing that I was deriving a passion and I didn't have much background in respect of local government and municipalities, that's how I sought employment within the city, which was a good thing for me. I started as an administrator in the records office in particular, in the health department, whereby I worked extensively with the health and environmental inspectors. That's what they were called by then, in having to make it a point that the city is being taken care of. So that was a learning curve in having to be exposed, on the basis of a local government. Then from there, I moved in different ranks. From an administrator, I then worked as a junior researcher within a health department in the Department of Epidemiology, whereby I was working with quite a number of medical officers. Remember, by then, the local government had a responsibility in having to promote healthcare services, the clinics, So I was part and parcel of the team that was making sure that there is efficiency in our clinics. And by then, at least the system was still easy because they could measure the members of the society so that they were able to provide better services. And then, interestingly, just to move forward, I then joined in the committee section within the council of the city, whereby I was one of the community officers. And that on its own, as a scriber and being exposed to the local government dynamics and the councils having to debate issues and having to make resolutions and the bylaws and interpretation of the bylaws. So I was exposed to those bigger meetings. And then, but the most fundamental one, that was when I worked in the Human Rights Information Center within the city of Johannesburg. It was fairly unorthodox or unconventional in having a center like that within the local government, because people will ask to say, but when you look at the purpose of the local government, it's just to promote social welfare to the communities or to render services. But then at the time, I think it was around about 1994, 1995, there was a lot of changes, obviously, and the introduction of our constitution, establishment of the constitutional court. So they thought it was prudent for that particular unit to sensitize, conscientize, and teach the members of the communities in that indeed you do have right to services, but also you need to take responsibility in respect of you having to pay for those services. So it was a fairly challenging time because not much of us were exposed to human rights culture, but by virtue of having to go to communities, having to conscientize them, teach them, and allowing quite a number of resourceful people to give talks. And that, to me, that was a journey of inspiration, because having to link local government and human rights culture. So that on its own, it created an exposure for me to attend bigger conferences, regional conferences in respect of human rights, which became an enabler that I could actually go in different countries having to make presentation pertaining the changes in human rights culture in our communities. So I delivered papers, one, I suppose, in Zimbabwe. In other instances, I was given an opportunity as well to present papers in Tanzania. And bearing in mind that at the time, it was a regional conference, and you may find that other African countries, they were well advanced on issues of human rights culture. So I had to learn a lot from that time. So basically, CJ, that's exactly what I did in the city of Johannesburg. But then it was not only that. I think later, in 2011 or so, I joined again the city, but I was within the entity being the Johannesburg Roads Agency. And that was good at the time because I was studying, obviously doing my MBA. So those skills were quite positive in having to do my job, because I was hired as a legal secretary, a company secretary, and having to sit with the board and a number of committees, being exposed to quite a number of things within the city. And bearing in mind that at the time, cities were never intended to generate revenue, but just to sustain themselves and having to provide services. But now having to work in an entity whereby there's a government element in it, and there's also a business element in it, to say, how do we best sustain the infrastructure on our roads by generating a revenue? So that on its own, it gave me a broader perspective in having to work within the local government without losing, actually, CJ, the element of legal orientation and understanding, because I was still heading the legal department within the Johannesburg Roads, whereby you know for a fact in such entities, there's quite a number of litigation in respect of tender processes, procurement. That was a learning curve, having to understand the committees and them having to make decisions. But obviously my role there, it was important for me to mitigate that there are no risk in us having to have litigation. So that's the experience I have within the local government, CJ. Thank you.
All right. But then when you returned to the city in 2011, you'd left in 2003 to start your own practice as an advocate.
Yes, no, when I
In
left
2003?
in 2000, I went to the university to study full time.
Yeah, no. I'm just following the information you provided in your form.
Yes.
And I'm looking at your career now, not the academic route.
Yes,
You say in 2003, between 2003 and 2008, you were at the Johannesburg bar
Yes.
practicing as an advocate.
indeed,
All right.
indeed.
And in 2008, was it 2 years when you were a state advocate?
Yes,
Uh-huh. And you also had a brief spell at the public protector.
indeed,
All right. And then you returned to the city.
indeed.
Okay. So when did you leave the city? In 2013?
I think it's 2013, CJ,
And you've been practicing since.
ever since.
What kind of a practice do you run?
Yeah, CJ, well, a bit vast.
Just briefly.
Briefly, no, I did mainly criminal. Obviously, those were the opportunities that they were afforded to me, but mainly my practice, it was on criminal law and also a bit of some civil litigation, labor in particular, and family law. So, but in essence, it was mainly the criminal law.
Did the situation change over the years?
It did. It did.
Alright.
As you grow and get to be exposed in other issues, then I tend to do other things.
All right. You've taken. You've acted as a judge in the High Court.
Indeed.
When and where?
I started, I think, late 2018. I think it was the last term. And then mainly I was in Johannesburg High Court and Pretoria High Court.
Okay. How long were your acting stints?
Since 2018, obviously in different terms, 2019, 2020, and during COVID, 21, 22. So I've been consistent. And in most instances, it was full-time acting stints.
Are you able to give us the total number of weeks or terms?
Sajay, I'd actually prepared a spreadsheet for the JP. I don't know if I have it here.
Well, maybe I should leave it to AJP Ledwaba. He probably has DCJ Mlambo's spreadsheets. Okay.
Thank you.
I imagine that you would have sat in all the courts.
Indeed, Sajay.
Did you do criminal trials, civil trials? Did you sit in the appeal court?
Yes,
Uh-huh.
I sat in full bench and on civil matters, on criminal matters. I presided on special motions. I presided on opposed motions, agent court, and mainly on criminal trials.
All right.
Yes,
And you've written judgments.
I have.
About how many?
I was just calculating, I think about 105.
Any of them
Judgments.
reported?
Well, not that I know of, but I know that some of them, they went to SCA. I think 4 of my judgment were actually confirmed by the SCA. I'm not quite certain. Maybe some other matters are still pending, where perhaps the court could actually overturn my judgment, but I've written extensively.
All right. When was your last acting stint?
I'm currently in
You're acting
criminal
now?
court. Yes.
All right. And you still have not picked up reserve judgments?
Well, for now, I don't have any CJ. Remember, the criminal matters, they take longer.
Or you are in the criminal court?
I'm in the criminal courts.
Okay.
So that's why I started with new matters. The other matters were in the stage whereby counsel had actually submitted their heads of arguments on merits. So I'm just waiting for them to argue so that I could prepare my judgment.
You listed a few parted matters. How are those coming along? Are they in progress?
Much progress, but I can safely tell you, CJ, that the last time there were a number of hurdles in my criminal matters because the state was struggling in respect of securing witnesses to come to court for quite a number of reasons. So that impacted immensely in us having to proceed with the matters. But thus far, there's a huge progress.
All right.
Yes.
AJP Letwaba.
Thank you, CJ. Good morning, Advocate Bokako.
Good morning, JP.
On the question of the
Oh, I'm sorry, AJP. Before you put your questions to the candidate, I forgot to welcome you and Premier Lesotho to the proceedings. It's never too late to do the right thing. Good morning and welcome, gentlemen. All right. Carry on, AJP.
thank you and good morning to other commissioners that are not greeted. I've got your spreadsheet here, which shows that you've acted for about 79 weeks. And in terms of this spreadsheet, I see that you are also strong, done a lot of criminal trials, opposed applications,
Yes,
and you've also been in the urgent court.
indeed, JP.
And as you know, that with the opposed courts in the Gauteng division, you get about 10 opposed applications which need to be finalized in 1 week.
Indeed.
And how was the experience dealing with these opposed motions and the urgent court?
Well, I'll start. Thank you for the question, Commissioner. I'll start with the opposed. Obviously, like you've just indicated, that you get to get a number. Obviously, what assists mainly, you get to be exposed to the files prior 2 weeks or so before dealing with the matters. Then that gives me an idea based on the practice notes of the litigants, safe to say whether do they need a day or 2 days or half a day, then I'm in the position to schedule, just to do a case management process for myself. If I've got about 8 matters, maybe for that particular week, I think obviously I'll indicate with my register so that I can talk to counsel beforehand to say at least let's rather deal with 3 matters, probably on day 1. Obviously, that will be influenced by the time allocated and requested by the parties. They could say 30 minutes, some they could say 2 hours. So I'll manage that process in day 1. And then in day 2, and if there's a need for a break, perhaps to catch up in other matters, I'll spread it on day 4 and day 5. So that enables me at least to have sufficient time to read. Then obviously, if there are opposed motions, because sometimes things happen, they might even settle immediately, which obviously the load gets to be lesser. Or in other issues, they might find that the preliminary issues that needed to be decided there and there, I tend to deal with them immediately and maybe dispose with the matter. But I make it a point that I do cover the time frame in having to deliver my judgment. But I can safely tell you that's a very strenuous process because you need to read extensively and understand the issues as a presiding officer before we are dealing with the matter.
And in addition to the work that you've been doing, you also had to deal with petitions, automatic review, and bail appeals.
Indeed.
And you managed to juggle all those things within the time that you had.
Indeed.
Right.
In particular, the bail appeals. Now, recently, we've been having quite a number of them. And I got a good exposure because I think I must have handled about 3 of them thus far, which it was a good learning curve as well. And the petitions as well, they can be very voluminous, but the good thing is you don't work alone as a judge. There is another judge that works with you. Obviously, you'll have your discussion and then you come to a conclusion. But the sooner you deal with them, the better.
You indicated and apologized for not attending the interview last year.
Indeed.
But you were interviewed in 2023, am I right?
Indeed. Yes.
So you are used to that hot seat.
You don't get used to
Okay.
JP at all.
Yeah. There were also some criticism by the practitioners that when they looked at your judgments, they experienced some grammatical and spelling errors.
Indeed.
Do you need to comment on that?
I can.
Yeah, briefly.
Yes, which JP, I appreciate, the comments because we can only learn by being assessed by others, which to me is peer reviewing. So I looked at that, and that was raised in particular in 2023, which I do admit, when I see myself now, even before, there's a huge improvement. I suppose it's based on personal assessment, but I do take into cognizance that these are constructive criticism, and I've worked immensely on them. And I can safely tell you, with my latest written judgments, I proofread so many times to make it a point that I do not want to be found wanting, but there is a progress.
And also this may be caused by the fact that we don't have enough researchers to look at the judgment, assist you here and there. And also with my experience, if you read your judgment twice, thrice, you tend to miss even obvious spelling errors.
Indeed.
So with the benefit of getting more researchers, I think this can improve.
Precisely. I've seen in Joburg now recently, there was the memo that was issued by the DJP in that there's quite a number of intents that are being now placed in having to assist us as judges and them to learn in the process. And that to me, I think is significant, JP.
It is also stated in one of the comments that if your appointment, this would send a negative message to the public. What's your comment on that?
I've seen that one of the bodies, which JP, I applaud them in having to concentrate to detail, because the assessment that they did, it's thorough, which it says to me, Thembi, you need to do better. But I do not think, JP, that could be such a detriment in me not to execute my functions. I think I respect the fact that obviously judgment writing is fairly fundamental because that's the document that needs to speak sense. That's the document that needs to show coherency and clearness, because it's not only the intellectuals of the courts and the judges that read the judgments, but the members of the public as well. They read the judgment. So therefore, there is a duty in me to improve in my writing. But I can safely tell you that beyond that, there's quite a number of things that I'm capable and I'm excelling in doing them. I'm not being defensive in that my writing is bad, but I think there is an area of improvement. And the more I'm given an opportunity, which I appreciate, that to me, it gives me an opportunity to continuously improve in my writing.
There's also a compliment. You are complimented that you conduct your proceedings fairly, efficiently, effectively, and you've got an independent mind.
It's true.
This shows that you are ready for the position and you think you can serve our people when should you be recommended and be appointed.
Definitely, JP. Thank you.
And then lastly, there was a question about your health. You know the environment, you've been there.
Yes.
Health-wise, are you saying that you are in a position to can face the challenges of the Gauteng division?
I am. It's fairly exhausting, I must say. So I make it a point that I really take care of myself, because you need a lot of energy and a lot of sanity. It's not only physical, but mental-wise as well. I think it's important to be sane. Thank you.
Thank you, CJ.
Do you have questions for the candidate premier?
Good morning, CJ. Thank you. Morning to all commissioners. Good morning, Advocate Bokako.
Good morning, Premier.
Now, Gauteng is a cosmetic province with all languages found here. I don't think there is any province that have so many languages like
Indeed.
Gauteng. Do you think in the long run, to ensure that the judgments are accessible to all citizens of our province, should we invest in ensuring that some of the judgments are delivered in other languages except English and Afrikaans?
Thank you, Premier, for the question. Definitely. Well, one example, I wouldn't go too far. We know for a fact that our CJ actually coined a judgment in Xhosa, which was commendable. I cannot emphasize much in respect of language, because language, it talks to your heritage, it talks to your identity, you as a person. I'll simply make one example, Premier, without taking much time, in that seeing that I've been exposed in dealing with criminal matters and having to represent the diversity of clients, and mainly, obviously, intellectually, they're not the same. And as counsel, having to understand your client, having to explain the legal issues to your client, it gets very difficult. Because one, you don't just simply go to your client and say, I'm your lawyer, then you start speaking English. You need to understand the person. And by virtue of you being understood is the language. So it's not only on the writing, Premier, but it's about the court itself, that in future, I will advocate in that our courts can actually be conducted in Zulu, in Sotho, in Pedi, in Tsonga, because we do have the interpreters. They play a very key role, but you may find that the interpreter that we have is exposed to the Zulu, Joburg Zulu, and you'll find that the accused person is from KwaZulu-Natal, in the deeper areas, whereby his understanding of the language is much deeper than the interpreter. But because of the services of the court that are there, sometimes you may find wanting. So, for an example, a typical example that I get to be exposed to, Premier, when a counsel will have to explain a Section 220 admission to an accused person. That's a very complex process in having to explain it, because you simply say you are admitting, and the client might think to say, you want me to say I'm guilty, and that's not the area. But if you fail as counsel to comprehend, understand, and talk to your client, it can be very detrimental. So I do advocate our languages. They're fundamental. They're being recognized in the Constitution. They talk to the identity of us as South Africans. So I'll advocate for that, Premier. Thank you.
Thanks for that, Advocate. I've seen in courts, you'll have interpreters when somebody speaks a different language, but when the judgment is delivered, the hard copy is only in one language, not even in the language that was interpreted in court. What do you think we'll need to do to ensure that aspect is also strengthened and is adhered to, so that those that appeared before you can also follow a judgment?
What I normally suggest in my court, because sometimes you may find that the judgment that I've written, it's fairly detailed with legal connotation and so on. I'll prepare a copy for myself, then I'll prepare a copy and give it to my register prior me having to deliver my judgment, in that immediately when I'm done in delivering my judgment, what I'll do, I'll take the copy from the register and give it to the interpreter so that he can actually interpret and translate. But what I will do, instead of regurgitating everything that has been said, I normally go to the analysis, the evaluation of my judgment, because it's easier written, and then the outcome. But then I always assure counsels to say, I am going to provide you with a copy of my judgment. Should it happen that your client does not follow, I think you have a responsibility in having to explain the reasons of the court.
Thanks so much, CJ.
Thank you, Premier.
Minister?
Thank you very much, CJ. Good morning, CJ and commissioners. Good morning, Advocate Bokako.
Good morning, Commissioner.
Let me start firstly with the observation by GCB, that made an observation which I found it quite interesting in terms of your contribution to constitutional values, around you being able to provide services to members of the society or destitutes at reduced value. I'm asking this in the context of access to justice, because one of the areas where there is a challenge in terms of access to justice is costs. So how are you able to run an effective practice while reducing cost to be able to allow for access to justice to your clients?
Thank you, Commissioner. Um, the CJ posed the question as to the area of my practice, and I indicated that I did criminal law. I have done a number of cases for the Legal Aid Board. And, that's pro bono, even though we were paid. It's fairly minimal, I must say. But because of the passion that I had and having to assist those that I need, I committed myself as a person to deal with that. But in private practice, whereby there's an attorney, obviously, they have their own prescribed fees and having to brief counsel, I'll provide my fees and the attorney. So the level of negotiation in terms of cost, I don't get to participate much. I suppose it's the attorney that gets to be involved in that. But significantly, I've done number of cases assisting the needy. Thank you, Commissioner.
No, thank you very much indeed. To the work that is done by Legal Aid South Africa is quite critical.
Indeed.
And they're quite constrained because of the fiscal environment.
Yes.
In one of your cases, namely State versus Dube J and others, 10 others, you made a point around that in the course of your case, you learned that Prevention of Organized Crime Act it's a complicated law. And part of that demonstrating that criminal intent necessary for poker convictions can particularly be in trick. Do you mind sharing with us, can you share with the Commission your observations and what you think should be done?
Thank you. Commissioner, that one deals mainly with poker, which is a legislation that is still fairly teething in our courts. And it's a legislation that is very complex, which covers mainly the issues of money laundering. And the critical aspect, it's the benefit of it. Because in other instances, for a matter that I did, the one that I'm making reference to, a number of accused persons that were present in that matter, it's accused that actually benefited without really being conscious that they're participating in money laundering. Some innocently, for an example, a mother, a sister, or a neighbor, or a girlfriend could be getting money from a boyfriend without having to ask, what is your source? So that, to me, it taught me a lesson that we ought to be a conscious society, in that if people get monies in their account, not knowing where does this money come from, I think we have a duty to question the source. Without questioning, you'll find yourself wanting to be a beneficiary in money laundering. So that's a complexity of it, that there is a thin line. Whether you're aware or you're not aware, you are bound to be guilty of the whole value chain as to how you receive the money.
Point, Sitja, on the matter. Is it the matter of a law being poker law being complicated, or is it a matter of advocacy that the public doesn't know? Because that's what I'm trying to understand. It's one thing, because I wanted to understand from what you're saying that it's a complicated law.
Yes.
So it's not about the act itself being complicated. And I'm interested, as you know, that I would be responsible for that amendment of the act or not amendment of the act. Now, seeing this was quite intriguing for me, in my responsibility to say, okay, is it difficult to prosecute? Is it difficult to prove a case? Is it difficult to be able to successfully have these matters, as you say, money laundering and all those issues that we could be able to prevent organized crime in the country, especially in the current context. So from your answer, I'm a bit confused whether is it the issue of the law or is it the issue of awareness by the public?
I think the major one is the awareness to the public. Also, in respect of the law itself, when it comes to prosecution, in respect of the matter that I'm making reference to, Commissioner, it would have been complex if the investigating officer in this particular matter was just a warrant officer or a constable without accounting and financial management understanding. That could be complex in that particular area. But if it's handled by people who are knowledgeable of financial management, FICA, and the rest, then it's easier to do that, because I think that's what we were exposed to. The person who was the key witness was a person that works, for an example, for SARS, fairly knowledgeable in terms of trails, fairly knowledgeable in terms of having to link the pieces, who got what, when, and money transferred to where and where. So I think our police, there's still a need for them to be trained immensely in having to cover that particular aspect. That's another aspect in terms of complexity. But in terms of advocacy to the community, it's very important. I cannot emphasize it much that the media ought to play the role, and the legal bodies will have to continue to educate people and councils as well, and attorneys in respect of these issues. Because you may find the attorneys, they do have trust funds, commissioner, and they invest monies for clients. So sometimes they might not even know the source of that particular investment. Thank you, Commissioner.
Thank you, CJ.
Commissioner Trolley?
Thank you, Chief Justice. Just to follow up, Advocate Bokako, I'm concerned at your answer to the Minister, because I can accept that the public might not be aware of the provisions of POCA. And I accept that some people might not be aware that it's important to understand where money appearing in your account comes from. But in this document that you provided, you said, I learned that receiving funds in an account without knowledge of its source is important. And I came to understand it may raise concern regarding money laundering. Now, as a judicial officer, I would have thought that you wouldn't have to learn that through a case, that you would know that receiving money in your account without knowledge of its source is a problem. So could you please explain to us why you only learnt these things and came to understand them during the case, and why you didn't have the judicial knowledge or grasp of how important it is to know the source of funding that arrives in your bank account?
Thank you, Commissioner Trollip. I think the matter that we're making reference to, I was a counsel in the matter. I wasn't a judicial officer in the matter. And it was for the first time, it was in 2018 when we started with the matter, for me to be exposed to the aspect of POCA. Thank you. Prof?
Thank you, CJ. Good morning, Advocate.
Good morning, Commissioner.
I want to ask you a question, and it's based on some of the judgments that I've seen that you have authored.
Yes,
without really dealing with them, just certain aspects that come from them. I mean, when one looks at it, mandatory minimum sentences were introduced in this country as a temporary emergency crime control measure, where there were those that believe that it will lead to harsh punishment being meted out to reduce crime. But it appears as if the legislation that was introduced did not live up to this kind of objective, or what generally people thought it will lead to. And we see more and more people participating in heinous crimes, serious crimes in South Africa. I just want to know, in your view, do you think that the Criminal Law Amendment Act has been effective in fighting crime, especially serious crimes in South Africa, and have assisted the courts in trying to curb this, what I call a pandemic in this country?
Thank you, Commissioner. If I may try. Indeed, Commissioner, these mandatory minimum sentences, you find them mainly on Section 51(1) of 1977 Criminal Amendment Act, specifically on the aspect of murder, for an example, and you'll find mainly on the aspects of the armed robbery, possession of firearm, and the rest. Now, in answering your question to say, this particular proposal in having to have minimum sentences, is it beneficial or effective? Remember how it came about. It derives back from S versus Makwanyane's case at the time, and the harshness of sentences, in that previously, when the courts were making determination in respect of sentences, they were not focusing on substantial and compelling circumstances of an individual. One, it's important for me to articulate that if a court will have to impose a sentence, you don't only look at an individual per se, the criminal. You look at the crime itself, you look at the interest of the society, and you need to understand what becomes the purpose of punishment. Punishment is not just to take people forever into jail, but we talk about issues of deterrence, issues of rehabilitation, and that you'll find in one particular case law, which a triad fact of Zin, to say you look at that. I do agree with you, Commissioner, in that even if people can be taken to jail for quite some time, because the standard minimum sentence for murder, if it's done with pre-planning, it's a clear case that it is life. And obviously people will have to be in custody for about 25 years. You'll be surprised that some of them, they'll still come back and commit crime. And that, I think there is an aspect that they called recidivism. And what influences them in having to do that is their social circumstances and the environment that they find themselves in. So it's not only the courts, Commissioner, or the criminal justice system that has a role to play in combating crime in our courts. The courts simply interpret what has been legislated. I cannot safely say there could be any other harsher punishment, for an example, for a person that has committed murder. Life is still significant, but then we need, as a community, to understand that you do wrong, then you go to court. But it's not, and if I answer you correctly, Commissioner, that it's not only the role of the courts in having to make it a point that crime is being kept. So I do not see any need currently in improving the current criminal justice system that we have in place.
It seems to me that your answer has in it the concept of restorative justice.
Indeed.
The exact meaning, place, and role of which in criminal matters remains unclear, particularly in serious crimes. So my question then would be, does restorative justice have a place in the prosecution and conviction of serious offenses in South Africa? And I'm asking that question based on the answer that you gave me.
If I understand you very well, when one talks about the word you said restorative, obviously is to maintain the status quo, equilibrium, that there should be balance. My understanding, Commission, restorative justice, I think it gives a sense of responsibility and accountability. In that, if we have done wrong as an individual, you don't only be taken to jail, you need to come back to the community and restore the disturbance that you have caused in the community. That is why I'm one of the people that subscribe to the parole processes that are taking place, in that individuals ought to be given a second chance to come and restore the wrong. Because by just simply taking them to prisons without them having to add value in our society, I think it's meaningless. I hope it answers you, but that's my understanding in terms of restorative justice.
No, it's fine. I will leave it there. We don't have enough time. Thank you very much, CJ.
Thank you.
Commissioner Gotzel?
Thank you, CJ, and good morning to you, Advocate Bokako.
Good morning.
Perhaps just then on the back of the professor's question, I see that you have done, as part of your community work, some work at the Maranatha Prison Ministry.
Yes.
What was your role there?
My role, it was fairly interesting initiative. It was a group of women, in particular from Soweto, from different churches, fraternal, whereby we'll go either on Saturday or on Sundays. Even obviously, just to educate the young women in particular, that was my area of focus. But then at some stage, then I made certain limitation in having to go to the correctional services because I might be found in conflict because most of my clients are there. But the other angle of the Maranatha, it was about the restoration that I was trying to articulate to the professor, in that there were a number of young women that have been incarcerated. And when coming back, we knew for a fact that they have criminal records, and which was an impediment in them having to get employment. So as a group of women in Soweto, we'll give them support, just to provide the basic necessities, establishing themselves into coming back to the communities. Because it is a known fact, Commissioner, that if one has been in prison for quite some time, there is a societal perception about the person. Either the family members, they don't get to appreciate and to understand you, the community that don't understand you. So we were playing the role in having to bring them back into the communities and make them to participate in young people's initiative, community initiative, so that they find themselves. And because I'm not going to lie, some of these women that we're helping, some of them went back to jail, because there were no means, they were not employed. So that's what I was doing with the Maranatha ministry.
Okay, because I was going to ask you, you spoke earlier about the recidivism rate, which is, I think, a big problem in South Africa. My view has always been, and particularly having been to several correctional facilities, that in fact the surrounds and the areas the spaces in which the rehabilitation is meant to take place is actually not conducive to rehabilitation. And I was wondering if you would agree with me that in fact that would contribute to the high recidivism rate.
Yes, you mean rehabilitation inside the
Yes.
correctional services or outside?
No, inside.
Inside. Look, I respect the processes within the DCS. When I'm exposed in dealing with the parole application, for an example, there's a number of trainings that are taking place. Conflict management, anger management, skills. Some of them, they do commit themselves in having to do that. And that becomes an enabler in them having to say, when going out, I'm going to do positively. But then in respect of resources being constrained, you may find that the DCS can actually consider in having to enhance other programs that are relevant outside, because sometimes you may find that are just personal skills which are not going to be positively contributing one having to skill to say, I'm going to start to work. Because if they have a criminal record, Commissioner, it's very difficult for them to do anything, which is something that in future I will advocate to the minister in that let's give our citizen a second chance, because the circumstances that we live in, you may find the areas where there's a lot of crime, the environment, it's not that conducive for people to get employed, and there's quite a number of external factors that makes them to commit crime. Not that I condone that, but I think people ought to be given a second chance, because if we're saying we are trusting the systems and the programs from the correctional services in having to skill them, whilst on the other hand, the very same DCS will not take them, for an example, to be their workers, then it becomes a futile exercise. Why then continue to train them? Because you need to trust on your systems, you need to trust in what you're giving to them. So let's give them a second chance to be the better members of the community.
Thank you. And then just, you've spoken about systems.
Yes, two questions, Commissioner Gotzel.
Okay.
Still have a long list. Commissioner Lepi.
Thank you, CJ, and good morning, Advocate Bokako.
Good morning, Commissioner.
Just one, is there any reason or that why you haven't taken senior counsel status given your extensive experience in the field of law as an advocate?
It never crossed my mind, Commissioner. There isn't any specific reason.
Yes, okay. And then the second one is, previously in 2023, there were some criticisms and also there were some undertakings and to improve. The current criticisms raised by the GCB, are they the same or related to the previous ones? Just to ensure that to check whether there has been some movement since the last time.
To be honest, you're quite correct, Commissioner. To be honest, it was mainly on grammar, mainly on the typing errors, not concentrating much into details. Obviously, they were basing their reasoning in my previous judgment, which I've taken cognizance into that, even though now they've raised the recent cases, which I think they are 2023. So I've perused on that, and in my assessment, I see there is an improvement. So it's genuine concerns. I can't take it any further, Commissioner.
Thank you.
Thank you.
May I follow up on that, Chief Justice? I just want to give you a proper chance to respond, because the GCB is referring to 2024 judgments in some cases, and it's not grammatical errors. They are referring to your reasoning and absence thereof. In the Kanu versus, no, that's the wrong one. In Royal Square Investors, which is a summary judgment case.
Yes.
The comment is that you actually misunderstood Rule 32.
Yes.
And the requirement that a plaintiff must file a summary judgment within 15 days of receiving a plea. You said this is to ensure that the defendant gets RD, but that's not the reason for confining it to 15 days. Can you perhaps tell us what the reason is?
Commissioner, without taking far, I've seen that. I've gone through the judgment and I saw the shortcoming. So I do not have any other explanation as to how I would have cured it, but I've learned in the process to say it was an oversight from my side.
But have you then learnt why there's a 15-day limit given to the plaintiff?
Yes, those are court rules, Commissioner, the prescribed court rules.
Yes, but what is the reason for it? There are many judgments talking about the reason for the 15 days, and it's not for the sake of argument.
Commissioner, I do not have a clear answer to that one particular aspect. I'll have a look at it.
Because I would suggest that learning from it would be then finding out if it's not RD, then, what is the reason?
I'll do that, Commissioner.
And then, likewise, there's another 2024 judgment, Mayor versus Mayor.
Yes.
Where they point out that you granted leave for appeal, but you didn't give any substantive reason. You merely said another court can come to another conclusion. And again, that was last year. Do you not think a court granting leave to appeal must say why on the facts another court could come to another conclusion?
You are quite correct. It's important, and given the threshold of an appeal, it's important for the judiciary to give reasons.
Yes.
Well, I suppose I might have consumed the submissions as they were made by the parties. Then I concluded that it will be amenable for me to grant the leave of appeal. But I do take your point, Commissioner. it's important in me having to do that. But I think in my other latest judgment from 2024, till date, I've given extensive reasons in respect of leave, why grant a leave of appeal.
Thank you.
Thank you, Commissioner.
Chief Justice, my questions are related to the same matter, if I'll be allowed.
Jump in now.
Thank you. Advocate Bokako, Commissioner Hassan here.
Good morning.
These are in follow-up to the questions that have been put forward. And I think you've acknowledged that there were some challenges in the past, but I'm interested in the precise mentorship arrangement, because that's what you said to this particular body in the past, that you would seek senior judge support. So if you could please set out the precise mentorship arrangements you've implemented, and you've just mentioned now, you've said there are judgments that show the progress. If you can specifically mention those judgments and highlight, I'm asking you to illustrate that progress that you've hopefully made.
In answering the first question, Commissioner, pertaining the mentorship, I do recall that immediately after the previous interviews, I sought counsel from the then JP to say, this is an assessment and analysis. I need an advice or counsel in moving forward. What I really appreciate, it's an open door policy within our division that I have access to all the judges, and that culture is being encouraged. So subsequently, there were 2 senior judges that they were allocated to me. For an example, should I have an issue in terms of legal analysis or understanding any principle, I will knock at their door, send them an email, write a memorandum for them. They will greatly assist. And then in respect of judgment writing as well, which was more critical, I'll make it a point that my first draft, I take it to them, we'll have a meeting, we'll say, okay, Thembi, I do understand what you're trying to say, but let's look at this, look at that, look at that. And that, it has been very beneficial to me in having to improve. Because I take the point, it was raised by the previous commissioner, that at some stage I struggled with the reasoning. I think I did not trust myself in having to apply my reasoning. I thought maybe let me focus mainly on precedents, but that on its own, it gave me courage to say, I can reason and I can apply my mind. So that has been excellent in respect of mentorship. I think the second aspect, Commissioner,
Yeah, it was related to that first question. I wanted you to mention some case examples from your most recent acting stint that show this progress.
Commissioner, I can make reference to the cases that I've submitted for this particular application, though they're mainly for criminal matters. But if you can compare what I've written and previously, it's totally different. These ones, they speak for themselves. I think I must have submitted about 3 of them.
Okay, and then my last question would be that the GCB is saying that your permanent appointment would send a negative message about the quality of judicial appointments. What objective indicators can you place before us to help restore that public confidence?
I think the JP asked that question. It's just the level of me being open-minded and being...
Sorry to interrupt you, Advocate. I'm asking you about objective factors, right? So someone who's sitting at home who will have heard that the GCB doesn't believe that your appointment would send a good message, what would you say to them?
That I'm confident that I can do better and I'm capable of doing better. And then I can not only be judged on that one particular aspect in me having to fulfill my duties as a judicial officer. So I strongly believe, Commissioner, to say I need the community and the public in particular to trust that I'm capable of doing more. And I will be exposed to a lot of training, which I am amenable to that. And I've seen that there is an ongoing training within our division, which it's fairly impeccable. So I'll appeal to the public to say they can put their trust in me.
Thank you, CJ.
Commissioner Mutulu Dlebo?
Thank you, CJ. Good morning, Advocate Bokako.
Good morning, Commissioner.
I think I asked the same question the last time we were here. We have a lot of experience in the local government procurement, and from what you're saying, you have never gotten exposure in practice. I just wanted to know, from the last time you were here up to now, do you still not get that type of work?
Fairly minimum. Not as much though, because I think, Commissioner, I've been concentrating mainly with the acting stints. So I haven't had, not that I haven't received briefs. Obviously, when I'm not available, I couldn't take any briefs, but fairly minimum.
The second one is the issue of your judgment writing.
Yes.
Have you attended the Bridget Mabanda course, or what else can you do?
The training?
Yeah.
I did. I've attended the training. I think about 2 years ago, if I'm not mistaken. I did.
Thank you.
Thank you. Commissioner again?
Thank you, Chief Justice. Good morning.
Good morning.
Bokako. You sat as a co-judge with Johnson AJ in the matter of ex parte Galela. It was an admission application.
Yes.
The candidates were owing fees to the university. And there was an issue of non-compliance with the rules of the LPC. But the LPC was not objecting to the admission. You remember that?
I do.
Yeah. When one reads that judgment, one gets a sense that you, as a person who was sitting with Johnson AJ, did not appreciate the level of poverty and unemployment in our country and the attempts that are being made to break the cycles of family in families. Why did you find it necessary to refuse to dismiss an application for admission for non-compliance with the rules when the LPC, as the custodian of the policies regulating admission of practitioners, did not object?
Thank you, Commissioner. I remember that matter. I think I was in Pretoria. It was a fairly awkward moment in dealing with that particular aspect. But bearing in mind that as a presiding officer, you don't only get to be driven by emotion or your social perspective in life. It's the prescripts of the law and what the law says. I take your point in that the LPC actually wrote in that they do not see anything impediment for her to be admitted. But obviously, the court is not only governed by what is echoed by the LPC. We respect the structure as a regulatory body because they look at quite a number of technicalities. But there are certain prescripts, guiding prescripts in respect of the admission. So what happened in that matter, it was not only the question of her not having money to pay her fees, because I think the matter was she did not have the certificate, even though she had the results that indicate that she has finalized her LLB, but she did not have a document, which is one of the requirements in your attachment. That was not the only aspect, but there was another aspect of non-disclosure in respect of a business, if I'm not mistaken, that she was running. And in respect of the attorney's rules, for one to be a candidate, you are not supposed to have any pecuniary interest, or you're not supposed to run any business, or you're not supposed to be exposed in anything that provides an income. So it wasn't just that particular aspect. But in understanding you, I totally agree with you that obviously we still need to be conscious as the presiding officer, because this particular aspect, I remember I made the research, even though I was not the scribe, but we had an extensive engagement. There is one popular decision, I think it was made by one Honorable Judge Victor. I think she was sitting in NCA or went to the SCA. There were conflicting decisions in respect of this particular aspect that you are raising. Then we tend to follow for the other one in that non-disclosure impacted in her not to be admitted. But I know subsequently our reasoning, a judgment was overturned by the SCA or the higher court.
Advocate Bokako, you are wrong. I was sitting with Judge Victor in that judgment of ex parte Judicial.
Okay.
You made reference to that judgment. You also made reference to the judgment of ex parte Makamu coming from Mpumalanga.
Yes.
You misinterpreted both judgments, ex parte Judicial and ex parte Makamu, both of which were saying that candidates cannot be, a court cannot refuse candidates an admission on the basis of outstanding fees. So it talks to the GCB's concerns about, one, your reasoning, two, your inability to formulate appropriate orders. Because if there is non-compliance with an LPC rules, you don't dismiss. You strike the matter of the role to allow the candidate to comply. Because if you dismiss, you are saying that this candidate should actually never come back unless he or she appeals the judgment.
I take your point, Commissioner. I wouldn't take any further, but I totally agree with you.
Thank you, Chief Justice.
Anyone else, colleagues? All right. Commissioner Shivan?
Thank you. Advocate, in the GCB, they mentioned case of BL versus AL, and they say you did not take cognizance of the fact that Rule 43 had been amended. Could you give us some background on how did that occur?
If I may be permitted to go through.
It's mentioned in 14.1. If you don't recall, I accept that you won't recall, but that's one of the criticisms they say.
Yes.
And then you also mentioned earlier that POCA was a complicated legislation, and you said you only dealt with it in 2018.
Yes.
POCA was promulgated in 2004, so that's similar to the criticism leveled against you by the GCB, that you didn't correctly interpret, you didn't take note of the amendment of the Rule 43.
Yes.
So that means it implies you're not keeping track of the latest changes that are going on in the law, because if you take the POCA example, you said you only dealt with the case in 2018.
Yes.
POCA was promulgated in 2004. That's like 14 years after you dealt with it.
Correct. But then, Commissioner, I don't know whether you're finished.
Yes, I'm
If
finished.
I may
Thank
respond.
you.
Yes, isn't it perhaps as counsel, you get to be exposed to a certain law or a prescript when you are dealing with that particular matter. So like I said, it was for the first time in 2018 that I got to be exposed to deal with matters of this nature. But I do understand that the promulgation was way over 2004. I take that into cognizance.
Thank you.
Thank you.
Thank you, Chief Justice.
President Mulemel?
Yes, thank you very much. Good morning, Advocate Bokako.
Good morning.
How are you?
Fine, thanks, and you?
I'm fine, thank you very much. I serve on the Council of SAJE and SAJE, South African Judicial Education Institute.
Yes.
So I'm just curious to find out whether you have any proposals regarding any additional training courses that you think should be, the acting judges should be assisted with.
Oh, definitely.
Yes.
Thank you. Definitely, Commissioner, there's always a need for improvement. You never get to know much. For an example, like I said, in our division in Joburg, every Thursday, there's training, and in different various aspects of the law. And you wanted to say, oh, I thought I knew this, I don't know. So I would greatly appreciate that. And in particular, seeing that I'm one of the mentees in having to mentor young women, I think there should be some kind of a program to say what is necessary, what is important for them, because those fourth-year students, obviously, that are preparing themselves to come to the system. So I suppose that there is a greater need in us as mentors as well, and them to be trained to say, how do we impart knowledge to other people? So I do support the view that we can expand training programs.
Thank you, Advocate Bokako. Thank you, CJ.
Thank you, President. We've reached the end of your interview, Advocate Bokako.
Thank
You're
you.
excused.
Thank you, CJ. Thank you, commissioners, for the time. Much appreciated.